Welcome, everyone. This is the virtual seminar presentation for Rules to Know When Getting Started. My name is S. Janelle Trigg. I'm a partner with Lerman Center in Washington, D.C., and it's my honor to serve as your moderator for this session. This session was previously called, What Forms Do I Need to Fill Out? Forms for short. For the past few years, the forum session has been at 8 o'clock in the morning for the WISPA America and WISPA Palooza conferences, which is pretty brutal, especially when you're in Las Vegas. So my sincere appreciation for all of you that attended those early morning sessions. And while I miss seeing everyone in person, I'm delighted that you can now view this session at your leisure any time of the day. My special appreciation to everyone at WISPA who's made these virtual recordings possible. I'm also delighted to have Chris Toomey from the Law Office of Christopher E. Toomey, PC, join me today. Chris and I have worked together on this session for a couple of the past few years. So welcome back to the K&J Show. A little bit about me. As I mentioned, I'm a partner. We call ourselves members. And I'm chair of our privacy and data security practice at Lerman Center. I'm honored to serve as one of the team members for WISPA Washington Council. I'm a member of WISPA's CALEA committee, and I've had several jobs in the federal government with decades of regulatory compliance and business experience. I'm also honored to serve on the FCC Advisory Committee for Diversity and Digital Empowerment as WISPA's representative. Delighted to introduce you to Chris Toomey. Chris, say a little bit about yourself.
Hi, everybody. Thanks for checking us out and listening in on this presentation. We appreciate it. So I've been practicing telecom law solely for the past 23 years, first in firms in DC and San Francisco. And then in 2002, I started my own gig, the Law Office of Me, and representing primarily small internet service providers and CLECs and voice over IP providers and now fiber developers. I helped create WISPA along with a bunch of the other old timers way back in 2005. And my practice is sort of full service, but just very specifically tailored to you guys. So I do regulatory contracts, dispute resolution, mergers, acquisitions, general corporate, and like I say, as my trademark of my firm, counsel to the competition. Sometimes I take the counsel role in terms of just being someone to talk to with my clients, and I enjoy that aspect of my job too. So thanks again for joining us, and let's get rolling.
Excellent. Thanks, Chris. Well, first, notwithstanding the title, this session is not just for new WISPs. We will cover a wide range of regulatory legal compliance requirements for WISP of all sizes and status, from new entrants to long-standing businesses. We will also highlight new developments and best practices. We certainly have a very full agenda. And while we understand that regulatory compliance may not be your top priority at this time, particularly during the COVID-19 public health crisis, there are certain regulatory requirements that should still be your top concern. And we're going to highlight a few of those. Our agenda today, we're going to break this into status of what type of services you deliver so it's a little easier to follow. First, we're going to talk about registration and ongoing compliance as a company. For telecommunications providers, including voice over IP providers, we'll cover FCC Form 499A and Q, CP&I, your state regulatory compliance, state county sales tax and E911, CP&I, again, I think that's listed twice, sorry about that, broadband internet access service. For FCC Form 477, Open Internet Transparency Rules. And then for both broadband internet and voice over IP providers, terms of service, usage agreement, privacy policy, acceptable use policy, Section 255, your access for disabled persons, CALEA, and the DMCA. Occupational hazard, for Chris and I, the disclaimer, this presentation is not intended to create an attorney-client relationship. This information is general and not offered as legal advice. This is for your educational purposes. These issues are very complex and nuanced, so we strongly encourage you to consult with your own attorney if you have specific questions. And any reliance on this information, because you have to rely on your own attorney, this is taken at your own risk. Chris, let's talk about registration and ongoing compliance.
All right, so when you're first starting up, it's kind of overwhelming. And if you look at this chart, that'll scare the most seasoned entrepreneurs out there. It actually isn't that difficult. You just have to do all these things in pieces, one at a time, and just to make sure you get the business up and going and do it properly. I would suggest also before you start, make sure you have a good accountant. You're not going to find an accountant, they exist, but you're not going to find one that in your area that typically understands telecom and internet stuff. But that's what people like me and Janelle can help you with when the accountants get stuck. But they know how to get you up and going. They can help you. We can help with getting registered with your state, and then also getting form registrations if you're operating in different states. But the taxes are something you need to set up from the very beginning. There's just a host of them, and it's very jurisdiction specific. You all have state taxes, of course, but there are localities, there are different utility user taxes, there's 911 taxes, all kinds of stuff. So as you're getting started, and if you've already been going for a while, this chart may help you sort of encapsulate all the stuff that you need to do to make sure you're running your business properly, and mostly to save yourself some hassle down the line. Audits are not any fun. So we're going to go through some more of the other things on the right panel in particular regarding federal USF and FCC reporting, and then some state stuff that a lot of providers are surprised that they have to address. The first general category, so that was for everybody. And now this next category is specific to those of you who are offering voice over IP. Now, first thing to keep in mind is if you are offering VoIP service as a provider to end users, you have to follow all the federal and all the state regulatory rules that are out there. It's going to look daunting as well when you see them all, but it doesn't take that much time to get up and going. And eventually, with the Universal Service Fund in particular, and the state counterparts, it just becomes an accounting function that you'll need to train someone on, or have someone help you train them on so they can do it as you're going forward. So the one distinction here is if you're acting as an agent, then you don't have to follow all these regulatory rules. But the definition of agent is you just have to you have to send along the bills exactly as you get them from your upstream provider. You can't mark them up. And then you get a percentage, some sort of spiff from your upstream. That's an agent. When you're delivering service from another provider reselling it, and then you're putting in your own sales plans and your own pricing and things of that nature, that makes you a provider, and that makes you subject to all this stuff that I'm going to talk about for the next 5 or 10 minutes. So the very first thing you need to do as a VoIP provider is go to the FCC, register for a federal registration number. It'll take you 3 or 4 minutes. You need your employee identification number, which you should have gotten when you first started your business. And then you get that number from the FCC. And if you're participating in any sort of Connect America Fund or any sort of program, or schools and libraries in particular, You have to file a Form 498. It's not that complicated. You'll get a service provider identification number. And so you can work through the process of actually getting money back and bidding on particularly E-rate kind of programs. As a VoIP provider, you have to file a 499 initial request to get a filer identification number. That doesn't take very long, but this puts you on the Universal Service Administration Corporation, what we all call USAC, gets you on their radar. They're the ones that manage the process for the FCC. So you submit this form, they send you a number, starts with an 8, 6 digits long, and then you're on the radar. One of the things to keep in mind about when you do this, though, is you have to sign under penalty of perjury when you started to provide service. So you have to go back and tell them, say, I promise I started on X date. Now, if you're a few years late doing this, they're going to fine you $100 a month going back to when you should have initially filed. That's why when you're considering offering any new service, particularly voice over IP, you have to jump into the regulatory arena before you start providing service.
Chris, just curious, you said under penalty of perjury. What happens if you aren't so truthful and you're trying to avoid that $100 a day, $100 a month fine?
Thankfully, I haven't run into that yet because I try to make sure clients do it properly. Probably what would happen is one of the USAC has interns that are checking on people, checking on companies providing voice over IP. They can go back and check, and they can request documents from tax services to see, or send you a data request asking to confirm that you have been truthful in what you're doing. If you lie, they will certainly go back and fine you, and there'll be interest and penalties. You may have to enter into some sort of compliance plan with the FCC, promising you'll never do it again. And I don't think you're going to get dragged out of your office and get arrested. That's probably unlikely. No one's got the time for that. But at the same time, it's just not worth it. And you could be denied access to the E-rate program. They're not going to want to give money to a company that's been lying about providing service. So that's probably the biggest danger in reality.
Right. E-rate and any other federal subsidy or federal grant program you may not have access to. I would think it also raises issues about your character as a company, and there may be even some licensing repercussions in terms of access to spectrum. So granted, I think $100 sounds like a lot of money, particularly if you've been providing VoIP for a couple of years, but in the long run, it may still be the cheapest option.
I absolutely agree. One other piece of that, though, is I do tell new providers that if you're just practicing, if you've got a few customers to make sure the system works, I consider that kind of a beta. And you're actively marketing to via your website or other means. If you're just kind of practicing to make sure it works, then you're okay. I wouldn't say you need to count that date. But when you actually start offering on a commercial basis and billing and receiving money for the VoIP service, then that's the date you have to actually acknowledge. All right, so let me say this one more time again, because this makes me crazy. So on Whistlepalooza floor, I was listening to a vendor talking to a potential customer selling VoIP. And he told him something to the effect of, you don't need to worry about all this regulatory stuff because we're filing for you. And I let him finish and bit my tongue. And then I went over and talked to him. And I said, hey, you can't be telling people that. And he said, well, yeah, we bill them for universal service. They pay us, and then we file it, which is somewhat accurate. I'll explain why that's accurate in a minute, but it's also dead wrong because they can't file all this other stuff for you. They can't file your 499A, which is your annual report explaining how much revenue you received and how much USF you charge and how much you will owe. But There's all this other stuff too. We're going to get to CLIA, CP&I, there's state reporting. Your wholesaler is there to provide you a service that you can resell. The regulatory obligations are yours and yours alone. So here's how it generally works. And this is why what the guy said on the conference floor, or exhibit hall floor, is true. If you owe less than $10,000 in USF, federal USF funds to USF once a year, you're considered de minimis. What that means is your upstream provider charges you federal universal service, you charge your customers, you collect it, send it to them, and they file it. As a de minimis provider, you are considered an end user in USAC's eyes, just in terms of reporting your revenue and paying your USF. So the way it works mathematically is you have to be selling, I think, around $6,500 a month in pure VoIP revenue. If you're hitting that level consistently, you will eventually become what's no longer de minimis, and you'll be considered a direct contributor to the USF program. And at that point, you tell your upstream provider, hey, stop charging me USF because I'm a direct contributor now, and you pay it directly. Once you become a direct contributor, then you start filing what you see on here, these 499 Qs. That's a quarterly estimate where a month before you tell USAC, this is what I generally think I'm going to collect in USF, so they can put that in their system and figure out what the quarterly contribution factor is, the percentage you need to charge for USF. They decide that based on the information that all the providers give them on 499 Qs. So April 1st is when the 499A is due, and the Qs then happen 3 months after that on a quarterly basis. So as you go through this process, the first couple of times you do a 499A, it looks really confusing. And USAC has tried to make it more user-friendly by, it used to be just filled in, it's a 7 or 8 page form, and you go in and fill in boxes, and you only actually need to fill in a few boxes with numbers. But now they ask a bunch of questions when you go in there, and it's sort of confusing if you're not fully versed in telecom speak. So usually it takes my clients a couple of years of doing this before they figure out to do it themselves, and it becomes a standard accounting function. Oh no. All right, hit the end button. All right, so when I started out a long time ago, way back in 1997, the USAC contribution factor was 5-6%. As you can see from this chart, it's gone up dramatically over the course of. It hit 25% in the fourth quarter, which was kind of shocking to a lot of people, especially those of us who remember it being 3 or 4 or 5%. The reason is because of these numbers track the decline of POTS lines, because for a while, voice over IP wasn't subject to USF. And then cell phones then took over POTS, and the USF rates that apply to them and how that all works is much different. So
for those newcomers to the industry, what's POTS? Plain old telephone service.
Plain old telephone service. Remember when you were a kid, or I guess some of you, I'm dating myself, but the phone that you talked to that was hanging on your kitchen wall, that one. That kind of phone, not anything else that we typically see these days. And you had to worry about talking on when you're in high school and you didn't want your mother listening into your call with your girlfriend, that phone. So that's POTS. So POTS declined over time, and now it was 25% in fourth quarter, went down to 21.1% the first quarter of 2020. The next quarter is 19.1 or 19.9, something like that. It's gone down a little bit, but it is a substantial chunk of money. Here's a chart that shows you just When I talk to clients about USF, it freaks them out because it is, and it freaks me out too because it's math and lawyers don't like math. I'm a letters guy, but this is probably the only math that I truly do understand. You have to figure out how USF works for each individual revenue source that you're collecting. So, for example, USF applies to a VoIP seat. So like the service cost, if you're charging $20 for each user on a bundled basis, so that includes local, long distance, both interstate and intrastate. If that $20 seat charge, that is subject to USF. What is not subject to USF is things like installation and maintenance charges and call waiting, caller ID, and call features, and various things like that. So when you first set up your billing system, this is where someone like me or Janelle can help you and say, all right, look, list out all the different things you're charging your VoIP customers for, and then we'll tell you which ones you have to apply USF to and which ones not. The other part of that is federal USF only applies to an interstate revenue. So when you're selling a bundled product like voice over IP, you have to figure out, well, all right, what part of that is interstate? The FCC, in its infinite wisdom, came up with this number: 64.9% of your USF accessible revenue for VoIP is a safe harbor, which means that you can just claim that. So if you have, $10,000 in annual VoIP revenue from your customers, I mean, $6,490 is subject to USF at whatever rate that is. So say it's like around 20%. That means you'd end up collecting about $1,350 in USF that you then would submit to your upstream provider and they pay. But you have to put it in your 499A. The one way around the safe harbor is what's called a traffic study, where you would go to your upstream, ask them for your call detail records, or some of them will actually do it for you. And you say, hey, all right, how many of my minutes were interstate versus intrastate and local? I just submitted a traffic study yesterday for a client in California, and their traffic study showed 22% of traffic was interstate, a very small percentage. It used to be that you had to do this every quarter, but just this year, the FCC decided, or USAC decided they only wanted this annually. So when you file your 499A now, you can reduce the amount of revenue that you have subject to USF if you submit a traffic study that shows, hey, look, this is the actual data. 22% is the lowest I've ever sent to USAC. We have the call detail records to back it up. This is his clients are doctors' offices and real estate offices and things like that. So those are legitimate numbers, and something like 85% of call traffic in California never leaves the state. So they might come push back on me about that, but if they do, we have the records and we'll give them to them. But it's helpful to consider the traffic study option depending where you are and what the nature of your customer base is, because it will reduce the overall cost on your bills to customers. They get really upset when they see, like, especially when the US have up to 25%. Maybe if you're selling particularly medium-sized businesses or even small businesses with multiple extensions, seeing that huge line item on their bill is sort of a shock. So if you can reduce that number through filing a traffic study, I suggest you do so. And again, once you owe more than $10,000 a year, then you got to start filing the 489 Qs, and you can use the traffic study percentage when you file those as well. The Qs work like an estimated tax, and then the 499A then they compare what you filed for the Qs, and then compares it to what you actually received for the A's, for the year, and then they figure it out, and they give you a credit if you've paid too much. That's not the only charge you have to pay. Once you get that set up in your system and you change the contribution factor every quarter, it should just be billing and collecting, and the money should be set aside in a separate, not a separate account per se, but a separate area, so that you know you have this USF pot. But there are other charges too that you're going to get hit with. So there's the FCC's annual regulatory fee that happens every September. And there's a portal that you have to go in with your federal registration number that you applied for and received. And you go in and you put in your information there. It should pop up immediately with what they think you owe. And you have to pay that. They used to send out emails reminding you, but they don't do that anymore. And then if you don't do that, then you end up on what the FCC calls the red flag, and the red flag database. And you're in there. Once you're in there and you haven't paid what you owe the FCC for any of these fees on this page, then they won't disperse you money for E-rate or for Connect America Fund, or if you're going to participate in the Rural Digital Opportunity Fund coming up, you won't get paid. So, and you might not even know because they don't remind you that you're supposed to file. So, put in your annual calendar September 1st. Check for the FCC's annual payment. You're also going to get these weird invoices from companies you've never heard of, because they're accounting firms that handle charges for the Telecommunications Relay Service, North American Numbering Plan Administrator, and the local number portability. Those charges are based on some tiny little number, like 0.003247 or whatever it is of your USF assessable revenue. So it ends up being a couple $100 for each of these when you start delivering services. And being de minimis doesn't save you from these. You have to pay these. So you'll get something from Brown and Company, I think it's the name of the accounting firm that does TRS. And it's not that much money. And I get emails. I always know when they send out their invoices, because I get emails like, hey, do I have to actually pay this thing? And yes, you do. The problem with those fees, once you get bigger, is that you're not actually collecting them. When you're having USF on your bill, on your invoices, the USF amount has to directly reflect what the FCC's contribution factor is for that quarter. You're not collecting anything for TRS, NAMP, or LNP, or for the FCC surcharge. So one of the things you'll see on, say, your cell phone bill, or especially if you're getting your internet from a cable company, you'll see a regulatory recovery surcharge. And I know you guys you don't want to put on what you think are made up nonsense charges on your bills, because that's not how this industry operates. But this is legitimate, and I've suggested to my clients that they start doing this, like $1 or $2 per customer. That helps, at least for VoIP customers anyway, where you're recouping some of this money that you're going to end up having to be out of pocket for eventually, especially when you get a little bit bigger. And it's totally legitimate as long as you disclose in your billing practices, at least in the beginning of your terms of service or somewhere, or on your invoices and back of them or something, where you explain what this thing actually is and what it covers. So that's the money side of VoIP for the Federal Communications Commission's programs. Keep in mind, if you're in 20, there are 22 states that have it, you at least have to register as a VoIP provider. And of that 22, there's at least a dozen, if not 15 now, that have a state component, their own state programs. California, for example, has 5 or 6 different little programs that end up eating up about 8% of a bill. And here's how it works. So say you take the safe harbor of 64.9% of that $20 VoIP seat. So of that $13.50, that is subject to federal USF and whatever the contribution factor is. So this month, 19.1, this quarter, 19.1%. But then that means 35.1% is intrastate. And if you're in one of these states that has their state USFs, Then you have to report back, sometimes on a monthly basis, sometimes quarterly, sometimes annually. Tell them, all right, well, 35.1% of my revenue was subject to your state program, and then they will send you a bill. And there is no such thing as de minimis for the states. So even if you're de minimis on the federal side, you're still going to get a bill from your state utility commission. So there are a couple other things that you need to keep in mind when you start providing service. One is, I think most phones now have these, but you need to make sure when you're delivering phones to customers, there's a sticker on there that says, hey, look, if the power goes out, E911 is not going to work. That's required, and it's standardized now, it happens. But you have to have some method where the subscriber has acknowledged this advisory. One of the easiest ways to do that is just to click through when people sign up for service. That's the best way to do it. The other thing you got to consider doing is having them put in their service address, their specific service address, into some database, so you have that in place. So you can share that with your 911 provider, whether it's bandwidth or whoever you're using. And this is the kind of thing, it sounds silly, but this is, as far as potential liability, this is one of those things you really want to be careful of, especially these days. You want people to know when 911 will work and where the first responders, what address they should come to. The FCC also expanded network outage reports to VoIP providers a while back. And this is, you have to be pretty good size for this actually to, if you're down for this extended period of time, you should think about how many customers you have, how many minutes you potentially have. And there's a portal, a network outage portal. You can go to the FCC, you put in your registration number and password, and you fill in the information explaining what happened and why. And it goes somewhere, and I really don't think anyone ever looks at it. So if you're even in doubt, you can go ahead and just fill in the form and put it in there. If it's an extended outage of any, like if you're looking at 3, 4, 5 days, you should do this as soon as you can, just in case. This is primarily for some of the larger providers to deal with, but it doesn't hurt to just follow it. It doesn't take very long. It takes 5 minutes, and you're done.
Okay.
Now let's talk about the other forms that you have to, other forms of compliance that you have to think about. One general category is called customer proprietary network information, which is a mouthful. When I first started this dealing telecom law, hold on a second, I gotta plug in my computer. That's embarrassing. All right. They handed me on my desk, I had business cards, an old-fashioned POTS telephone, and Newton's Telecom Dictionary. It's about that thick, and it was just full of acronyms. And it was quite a learning curve. So let's just call this CP&I, use the acronym for it. What is it? Well, it's basically the call records of the customers, who they called, how long they talked for, and then what services that customer orders from you. This didn't actually used to be a big deal in terms of VoIP providers. It's been a requirement for regular telephone service since the 1990s. But the idea is that these records have very sensitive information in them, and the entity that controls them should protect them. So there are 3 pieces of CP&I compliance. The first is you have to have procedures for how you go about protecting this CP&I data. One of the first ones you should do, another one that should be part of perhaps your click-through when you're doing 911, is you should have a PIN code set up for anyone to get access to this data. And let me tell you a quick story about why this matters. So I had a client in Michigan, and he was a WISP offering voice over IP, and the husband believed that his wife was having an affair. So he called up the WISP, and they had gone to high school and played football together. They were buddies. And he said, "Hey, can you give me these call records? I want to know what's going on." So his buddy gave them to him. No big deal. Here you go. It turns out the husband was right, but as it turned out, the WISP should not have provided them those records to the husband because he didn't sign up for the service, his wife did. And his name wasn't on the bills, he wasn't anywhere in the system. So legally, she's the only one that had access to this data. So eventually, as it turned out, now this WISP is providing service to his wife for the rest of her life for free. That was part of the deal. It could have been a lot worse. So it's just a story to explain to you why it matters. So in addition to having these procedures in place, you need an employee manual and training guides that you have anybody in your organization that has access to this data. They have to sign this piece of paper that says, yes, I understand this. I understand the disciplinary process. If I break the rules, you stick it in their employee file and keep it there. And you need to designate a CP&I compliance officer as well. And there is, for all these, what you need to do, make sure when you're handling the CP&I is remember there are three different pieces to it, like we just discussed. There's employee training. There's a manual you need to have in place that explains to your customers or to your employees how you go about protecting CP&I. And then every year you have to file a CP&I annual certification statement. It's not that complicated, but you have to file it by March 1st or the first business day after that annually, where you promise that you haven't had any data stolen and that you protected it, and then you submit it. If you don't, here's the problem. You could end up getting an envelope from the Enforcement Bureau threatening you with a $25,000 fine. And it's just not worth it. It's easy enough just to put this in your regulatory calendar that you got to get this thing on file. And the FCC will send a reminder from the Enforcement Bureau, usually around February 1st of the year, telling you that you have to do this.
Now, note that if you have not met the requirements of the certification, again, this is another certification under penalty of perjury, you do not want to file. It is worse to lie to the FCC that you have met all the requirements. It's best to get your requirements in order, bring your system into compliance, bring your forms into compliance, bring your employees and training into compliance first before you file. That's important. And one of the other things that we didn't emphasize because of our technical difficulty is there is no small business exemption for CP&I. It's not like the broadband privacy rules that were adopted and then repealed where there was a small business exemption. Every VoIP provider, every telecom provider must comply with CP&I. One of the questions I always get from clients is, what's the difference between CP&I and CALEA? We're going to talk about CALEA in more detail a little bit later, but CALEA is the Communications Assistance for Law Enforcement Act. The two work together. They're not the same. CP&I governs how you handle and disclose customer personal information, the call records, the services purchased, location-based, the other call data that Chris mentioned. CALEA governs how law enforcement and any regulatory or authorized body will then access your system or access your network for national security or other lawful purposes. One is the more privacy oriented, the other is law enforcement oriented. Understand that you can violate CP&I rules when you comply with law enforcement. That's why you need a policy, an internal procedure to understand when law enforcement comes knocking, and it's not a matter of if, it's a matter of when. ISPs are very vulnerable to law enforcement inquiries, whether or not you're going to disclose in an unlawful manner the CP&I of any of your customers. So the two work hand in hand. Neither one have a small business exemption. All providers need to comply with both.
And here's just real quick, here's the list of things that you have, the elements you have to file in your certification statement. And like Janelle mentioned, you can get in trouble not only for just not filing this thing, but if you're filing it wrong or if you're not being truthful. Even if you just miss a few pieces, you can get threatened with a fine of $500 or whatever. So it makes sense to make sure you're doing this properly and get it on file on time. There's a lot, I'm not going to go into this too much, but this is one of those things. If you go to the FCC Enforcement Bureau's webpage, you can get a list of everybody who's gotten dinged for various enforcement activities. And in this case, CP&I is one of those things you'll see pop up again and again and again. And cell phone carriers,
and this is the most recent one. This was just a couple of weeks ago. And it's amazing that it was against the largest 4 carriers. I don't understand how they thought it was okay to share location-based data, which is one of the most sensitive type of CP&Is, and sell it to a location data aggregator who then sold it to another third party who resold it to another third party. I just don't understand why this was a problem to begin with in the sense of disclosure of location-based data without the subscriber's consent. But the FCC certainly took it seriously. $200 million in fines, $2,500 for each successive day of violation, $40,000 for the first day. Granted that these were large carriers, but for location-based data, the FCC is very serious about it, particularly when this was a news report, right? It was publicized back in 2018, and the carriers continued to do this. So lesson learned. Certainly don't want any small carriers getting dinged for something that the larger carriers have already provided a lesson for. Let's go to the next slide.
All right. So Janelle, why don't you get into 477?
Okay, I'm not going to go into a lot of detail here, but I do want to give you more updates. As you all know, Form 477 is the FCC's report that required by all facilities-based broadband providers. It's filed twice a year, in March for data collected as of December the 31st of the previous year, and for September, the data collected from June 30th. It is a report where your internet access service is offered at speeds exceeding 2,000 kilobits. For fixed providers, it's the list of census blocks where you currently offer service or you could offer service without an extraordinary commitment of resources. We all understand that FCC Form 477 is not the most accurate data, and census block reporting can be a bit misleading. If you have one particular subscriber in a census block, you count that census block as being served. The FCC, as well as every other federal government agency, and certainly folks on the Hill, want more accurate data on deployment of services. So the FCC has undertaken, we can go to the next slide, trying to update their Form 477. These were changes adopted in August 2019. The FCC established the Digital Opportunity Data Collection that collects geospatial broadband coverage maps from ISPs, trying to advance the Commission's universal service goals, basically to identify in a more precise manner who has broadband service, who does not at particular speeds. The Commission is adopting a crowdsourcing data collection procedure to get public input from people to basically call in and identify whether they're being served or not. The Commission's also trying to reduce some of the Form 477 recording requirements, reporting, I should say, to reduce the filings for and the burdens for small carriers to modify the collection so you can incorporate new technology. They've been seeking comment on how to reduce that. WISPA as an organization has been actively involved in this process, particularly for fixed wireless providers, and helping the FCC understand that your deployment is not based on streets or road segments. You're not cable, you're not fiber, and fixed wireless can be deployed pretty much anywhere. Next slide, please. The Commission's also looking for, I said, technical standards, and then specific location-based deployment data, more accurate, reliable mobile data, and sunsetting the 477 requirement. It has not sunset yet. As you all know, you were subject to the form to be filed just this past March. And I can tell you that it's not going to be sunset for some time because there's still procedures and implementation in place in order to get more accurate data. NTIA is also engaged in this process, and so is the Hill. It's critical. I can't emphasize how important it is for you to file your Form 477. The Commission is basing, as so is most other agencies at the state level as well as federal level, there are billions, if not trillions, of dollars that will be allocated to bridge the digital divide. We already know that there's $20.4 billion for their upcoming Rural Digital Opportunity Fund. CAF 2 has billions of dollars. The RUS has several programs, one which is a pilot program for $600 million. And we heard just recently that COVID-19 stimulus bills and further bills will have more infrastructure money. So 477 data is being used to decide where to deploy these trillions of dollars to help ensure that everyone in America is connected. In fact, there's a challenge process. There's a deadline of April the 10th for you to challenge any WISP that is listed on the census blocks that are eligible for funding from the Rural Digital Opportunity Fund, or DOF-Fund. You have until April 10th for you to challenge the census blocks the FCC has identified as being eligible, meaning that there is an unsubsidized provider. You're not getting any government money, you are unsubsidized. And if you are not offering voice and broadband of at least 25.3 megabits, that's eligibility, which means someone can come in and overbuild you because you're not shown as providing 25.3 service for voice and broadband in that area. The Commission is only using data from June 2019 report. I should say basically that would be the December report, but data as of June. So you need to let the Commission know you're in a service area, and that has to be based off your 477. If your 477 has not been filed, file one. If it has not been updated to show how fixed wireless has grown exponentially, update your 477. I cannot emphasize this enough. One of the other things that the Commission is looking at is the report submitted by WISPA, as well as other telecom providers like US Telecom, trade associations. This is the partnership with CostQuest that we initiated the broadband mapping initiative back in 2019 of April. We basically have tried to find a better mapping strategy and better modeling strategy. And you can look at that report on the FCC's webpage. We're hoping that the Commission, as well as the Hill, will take some of the examples and modeling recommendations that we've made. Next slide. There were enforcement decisions during the previous FCC administration. Given the emphasis on accuracy, the heat the FCC is taking from the Hill on more accurate as well as timely data, I expect more enforcement decisions coming out of this administration. This just happened to be one of $10,500 penalty. I think we'll get more to come. Next slide. Okay, very briefly, just to let you as a place marker understand that broadband service providers, as you know, are no longer common carriers. The FCC had initially preempted any state rights to impose net neutrality legislation or requirements on ISPs. And in the court decision that upheld the Restoring Internet Freedom Order, which restored WISP to information service provider status, took you out of Title II land, they also vacated the FCC's broad preemption of state rights to regulate intrastate communications. The FCC did not have legal authority for that blanket preemption. It will allow, the court does allow the FCC to preempt states that conflict with the federal deregulatory approach. California, Washington, and there are a couple of other states that have their own net neutrality laws, have not yet been challenged by the FCC. Just beware that your individual states may have additional regulatory requirements of you just because you're an ISP. Next slide. As I mentioned, you are back to being an information service provider. But unfortunately, that did not eliminate your consumer disclosure requirements under the Title II order. The FCC basically adopted an enhanced open internet transparency requirement. This is required of all broadband providers, including small providers, no exemption. We went back to the 2010 transparency requirements. The Commission did eliminate some of the burdensome additional reporting and direct notification requirements in what was the 2015 Title II order, but you still must disclose certain of your business practices, rates, network management procedures, security measures, and that has to be submitted to the either FCC or posted on your website. Next slide. This is important. The Commission basically said that they want customers to be able to shop online, to have full disclosure of what your services are, so that way customers can make informed choices. And that includes how you develop, market, as well as what fees you provide. So this is a very consumer-centric requirement. I understand that not everybody likes to have their fees and rates and all their information on the website. Unfortunately, that's the requirement that the transparency rule imposes. Next slide. Your transparency statement or policy, you could call it either one, it controls over inconsistent service agreements, website postings, advertisements, or other public statements. Basically, this means everything that you say to the public, your consumer-facing documents, all need to be consistent. They all need to work together. Next slide. Here's the requirements. Your network management practices, whether you block, throttle, what you do in affiliated prioritization, paid prioritization, your congestion management, whether you impose certain obligations for applications or device attachment, and your security practices. Next slide. Performance characteristics, not just your service description, and that is by whether it's residential or whether it is by business, what your speed ranges are, but your expected and actual latency, access speed, suitability for real-time applications, and whether you have a non-broadband internet access data service, whether it impacts that last mile capacity. Commercial terms. Here's the real sticky point for a lot of WISP. I understand that. Your monthly prices, but your usage-based fees and any other fees, as well as your privacy policy and redress options. I encourage you to not put the actual prices in your open internet transparency requirement, but to put a link, list what your services are, whether it's by residential, whether it is by business, commercial, whether it's fiber separately from wireless, whether you offer VoIP or whatever, but put a link to more data on your website. So that way, when you change your prices, and you can change your prices, you also don't have to go back and change your open internet transparency statement. So basically, list all those, but have an active hyperlink to where a customer can find additional information, more specifics on those fees and your services. Next slide. 255. Chris, you want to cover that?
Let me add a couple of things on the open internet statement. A lot of clients have come to me and they've given me what they've stolen from someplace else, some cut and paste version.
Ooh, that's not good.
You need to make sure that what you're posting, what you have, and it has to be posted on your website. Keep that in mind.
Or filed with the FCC, and I think that's worse.
That's worse. Put on your website so you can change it as things come up. But make sure that what you're using actually represents how your business operates. Particularly, this is particularly important for WISPs because you will have to, and you do have in place, I know, certain network management principles or plans, how you balance the traffic load on your APs. So you need to disclose how that works and what that actually means to the customer. And this needs to be clear enough that that any customer can understand it. It's not supposed to be some legalese document. It needs to be actually how you manage your network, what you do if they're spending all their time BitTorrenting and things like that. So make sure what you have posted is accurate, and there are people like me and Janelle and many others who can help you put this in place relatively simply and inexpensively. So just please be careful with the cutting and pasting. And one more thing on this is you've probably found that customers are getting a little bit more
savvy
and more open to complaining if their service isn't working properly. And it's just going to get worse as everyone overloads your network with Netflix usage at night, or nowadays in the middle of the day,
right,
with schoolwork and distance learning things, and moms and dads trying to survive on Zoom calls all day. So you need to be careful about how you disclose this, because customers can get angry. They can file an FCC informal complaint. The simplest way to defend yourself against one of those is to just say, hey, look, here's the open internet transparency statement on my website. I've disclosed this to my customers. This is how it works, and that should be the end. So make sure this is done properly, just to protect yourself from further hassle.
You are also subject to FTC, as in Federal Trade Commission enforcement, when your other documents are not consistent with your open internet transparency statement. A couple slides back, I mentioned that statement controls over inconsistent service agreements, website postings, advertisement, other public statements. So if you're cutting and pasting from someone else's open internet transparency statement, you are bound to that. That means that your other documents, if they don't say the same thing, it means you have now deceived. You have a deceptive statement. And the FCC governs deceptive and unfair trade practices. And since you are an information service provider, the FTC has jurisdiction over your advertising and marketing and business practices, as well as the FCC over your open internet transparency statement. And every state has an unfair and trade practice law You may be sanctioned to state problems if indeed you have a customer that complains that what you've disclosed is not accurate. Just a little something to think about.
And one more piece on that, just to pile on here, is there are class action lawyers out there who are looking for these kind of discrepancies. And I've dealt with 3 of these in the past 5 years where some class action troll lawyer is out there trying to gather up these kinds of complaints and then filing state lawsuits seeking damages. So this is really an important thing to make sure you've got locked down.
And I've heard rumblings because I also engage in quite active privacy and data security practice and work with quite a few attorneys across the country. I've heard rumblings from consumer advocacy groups that are more concerned now during this COVID-19 crisis that since everybody's online, their antennas are up, that their violations of privacy, violation of statements. You know, we got everybody sitting at home now looking for a way to basically hold ISPs to a higher standard. So I just want to raise that there's already talk about concern about too much power in the hands of ISPs in terms of knowing everything that you're doing.
Yeah, and to highlight that too, look at Zoom. They're getting sued for privacy policy violations already. And then we only been at this sheltering at home thing for 2 weeks.
Right.
So
it's going to get worse.
Gonna get worse.
Yeah. Not just COVID-19, but the repercussions from COVID-19 are going to get worse. Okay, 255. Let's go through the rest of these.
This is a quick and easy compliance obligation. You have to do it once a year. And there's a link at the bottom of this page where you go in and you put in your federal registration number, your password, you click some boxes promising that you've got your operating procedures are consistent with Section 255's disability access record keeping rules. This used to only apply to manufacturers, but now it also applies to service providers as well. And the equipment you're providing, because it's FCC certified, does actually meet 255's requirements. All you have to do is go in, click these buttons, and acknowledge that that's the case for your company, that you're providing FCC authorized gear.
Note that this too is a ripe opportunity for class action because of disabled persons accessing the internet. Like I said, the consumer advocacy groups and consumer protection groups are just say active in this area of trying to find ways to protect consumers better. Let's talk about general documents. This is for every provider, any service that you offer. Terms of service and use agreement. Note that a lot of carriers, a lot of WISP and ISPs are offering no contract services where there's no extended length of time that someone has to sign up for your service. A no contract does not mean no terms of service or use agreement. You still must have rules of the road, how a customer can and cannot access your service. Chris, I think you've got some more things to elaborate on.
Yeah, and real quickly on this, this is another one where your cut and paste job may not actually be a very good idea. You need to make sure the terms of service agreement actually reflects how you provide your services. And like Janelle said before, it has to tie into your open internet transparency statement, because that any discrepancy between the two can cause you trouble. So with these things, you have to make sure that and I suggest you post them. So we're telling you, like, and then you need to see, customers need to be able to see this stuff. You should have a legal link or something on your webpage where you can click on it, and then all these things show up that customers can look at. They're probably never going to look at them, but the lawyers, the advocacy organizations who are considering causing you pain, they're the ones who look at it. So the more professionally this is done and the better it looks, the more likely that they'll just skip over you and go bother some other poor ISP. So make sure that this is done properly.
And in the privacy policy, that should be a separate document. Most WISP ask me, do I need a privacy policy? Absolutely yes. First of all, there are various state and federal law requirements. You want to manage a customer's expectation of how you will use their personal information. And of course, if you're a VoIP provider, you have to disclose and to protect their CP&I. So if you're a VoIP provider, you have CP&I obligations to disclose certain things. So yes, you need a privacy policy. There are certain states that require you to have a privacy policy. California, Delaware, Connecticut, Nevada, those are just a few. You also want to have a privacy policy, your terms of service and use agreement, your E911, and that acceptable use policy. That acceptable use policy, basically the rules of the road. What is acceptable use? What can, it's a little more broader than your terms of service. It's a specific list of things that customers can and cannot do. Your terms of service are going to include your cancellation termination provisions, your payment requirements. You may have a no contract agreement, but you still want to get paid. When does someone have to pay you? All of these things should have a click-through affirmative consent process online. You want to secure someone's express consent to all of these obligations, in addition to that E911 disclosure. So these are governing documents that all work together. In terms of the privacy policy, not just do you need one, but you need to have certain items in them. I encourage you to also view the privacy session, which will be recorded tomorrow and available along with this one called Developments on Privacy Rules. I'm delighted to join Ari Storch in presenting that session. We're going to go into more detail. That's a whole hour of privacy policy discussion. I'm only going to take another few seconds to talk about just some general requirements you should be aware of. State law, California Consumer Protection Act, Privacy Act, CCPA. If you don't think you're subject to CCPA and you're operating out of California, please think again. It is a very broad law, as well as all the other California laws that apply to any consumer, and consumer is very broad, that may be even visiting your state or your service area. So CCPA is a new California law that is very extensive. You've got a host of other California laws, other state laws. You also have ISP specific laws. Maine, Nevada, and Minnesota have ISP specific privacy obligations. They carry criminal penalties and or fines. Again, attend the session, view the session, the privacy session for more detail. Let's talk about other things required of all providers. I mentioned CALEA. Which is the Communications Assistance for Law Enforcement Act. As we discussed already, it applies to all telecom and broadband providers, VoIP included since 2007. You must comply with CALEA upon launch. If you are not, this is another regulatory requirement that is very important and critical. This is the statute that requires you to have certain technical standards in place so law enforcement can access your system. Next slide. You have to file and maintain a system security integrity plan with the FCC. It is due at the time you launch, and it's due within your 90 days of a merger, divestiture, or amendment. For those WIPs that are acquiring new companies, you need to update your SSI plan. I can't emphasize how important your CALEA, SSI, and other requirements are, particularly in this day and age of foreign and domestic terrorism hacking ISPs. I can assure you that small ISPs are just as subject to being hacked or accessed in an unauthoritative manner as large ISPs. I've talked to quite a few Secret Service personnel as well as FBI for hacking done on a foreign scale. You are not immune from being hacked from anyone in your service area or anyone across the world. It's just a matter of time. So you need to have your CALIA requirements in place. Next slide. Here, more requirements. You can read these yourself. Note that this certification that you have to file on an annual basis, that you have complied with the CALIA and CP&I rules, that you have a certification to start in date time if you have an interception or access, the law enforcement personnel, the name of the person signing appropriate legal authorization and what the law enforcement access was. This is, again, another certification to be filed with the FCC. Excuse me, it's not filed with the FCC, but it's still under penalty of perjury. You need to keep this for some time. And there should be a whole system internally on how you access and how you review law enforcement requests. Just because law enforcement comes knocking, and sometimes they will just show up at your door, does not mean they have the proper authorization. You should have an internal process on how to vet and to determine whether a law enforcement request is accurate before you give out any information. You could violate the CP&I rules if you don't indeed follow the requirements under your law enforcement vetting process. Okay. For those of you that aren't familiar with the WISPA CALIA standard that we worked on with the FBI, you can use, first of all, a third party for compliance. There are several companies that will do your law enforcement vetting and access and whatever for them. You can look on WISPA's WISPA's website, or you can email to their admins to get a copy of the standard that we've worked on. This takes into effect your unique technology as a fixed wireless provider and what systems can be low cost and low impact. DMCA. We're at the end, folks. Digital Millennium Copyright Act. This is the cheapest legal protection that you can get from third-party claims of copyright infringement. Digital Millennium Copyright Act protects you from legal liability if your subscribers, your customers, violate someone else's copyright. In the ISP world, that means if someone is downloading content that they don't have the authority to do so, that they're starting their own website with someone else's content. Section 512 of the DMCA provides that safe harbor, but only if certain procedures are met. If you filed a paper filing for DMCA, that paper filing is void. It was voided as of December 2 years ago. You now have to file electronically. And if you filed electronically a couple years ago, you will have a renewal coming up. You want to keep your designated agent filing accurately. There are a billion reasons to comply with the DMCA, and I'll tell you why after we go through requirements. First thing, appoint a designated agent. Register that DA, specific content. You've got the full legal name, physical address. That DA can be an individual, a title, position, department, or third party. Telephone number, email address. From my experience, I have been a designated agent for thousands of clients, our radio and TV clients. You want to set up a separate email address just for your DMCA. It could be called DMCA designated agent at whatever the end domain name of your company is. You will get so much erectile dysfunction ads and so many other kinds of email on that email address. You don't want someone's personal or work email address to be out in public like that. So I suggest you set up a whole separate email box, and that way multiple people can access it. Your information in your DA registration with the U.S. Copyright Office must be identical to what you post on the website. Both need to be current, both need to be accurate. If you fail to retain accurate, if your email address is changed, your telephone numbers change, the name of your agent has changed, you will lose the protection of your safe harbor. It's only costs $6 to file with the Copyright Office, a DA agent information with the Copyright Office. For $6, you've got copyright infringement protection, assuming you also comply with having a post-infringement notification process on the website and how to do a counter notification process. A subscriber who is challenged and basically you contact them and say, someone has said you are downloading movies from or music from EMI or whatever, they can counter. They can say they had the authorization to do so. There is a formal process. This is very simple. It's all laid out on the Copyright Office's page. Next slide, please. You also need to develop and enforce that policy. If someone, the agent of a copyright owner or the copyright owner themselves contacts you via the process you have on your website, you have to develop and enforce that policy for handling a copyright infringement. You have to ask that subscriber, notify that subscriber to stop doing that. You need to have a policy and enforce that policy for repeat infringer. The DMCA does not define repeat infringer. You need to define that yourself. Is it 3 strikes, you're out? 6 strikes, you're out? 6 strikes, I would suggest, would be the most. Something higher sort of looks a little funny. How you handle counter notifications, how you handle the notices, and how you handle the legal requests. You will get legal requests from copyright owners who want to discover who your subscriber is, which is also why you don't want to say on your website that in your privacy policy that we protect, we value your policy, we value your privacy. We will not share your personal information with anyone. That is not true, because you are required by law to disclose the name of the infringing subscriber to a DCMA copyright owner process. You are required to disclose personal information to law enforcement. That's why your privacy policy needs to reflect your real business practices. Next slide. The reason why there's a billion reasons you want to comply with the DMCA is because there was the word was shocking, recent court decision, jury verdict, that Cox Communications was ordered to pay $1 billion in damages to a coalition of music companies, EMI, Warner Music, Sony, and others, that the ISP was found to turn a blind eye to piracy of over 10,000 musical works. They had an unreasonable repeat infringer policy. They had a 13 strikes, you're out. And even then you weren't out, you were reinstated maybe a few days, a few weeks later. They did not enforce, they did not honor the DMCA takedown request. They pretty much ignored the DMCA overall and got deemed $1 billion. That was pretty amazing, but this was the second time they were in a multi-million-dollar lawsuit, and there are other lawsuits against ISPs of all sizes. So for $6, folks, please register your designated agent. Have your DMCA policy posted on your website. Have it incorporated with your terms of use agreement, and keep your DA agent data accurate, as accurate as you can. Chris, did you have any follow-up thoughts before we sign off?
I just want to add one more thing before we sign off. Thanks everybody for listening in with us. One of the things we've talked about as a theme through this is the increased attention being paid to broadband now. So with this terrible health crisis, the broadband industry has come into focus, how critical it is for people to try to continue some semblance of normal lives and to work and learn and going forward. We don't know how long this is going to go on. The government is going to end up spending a bunch of money to help specifically you guys go out and bring broadband to areas that don't currently have it or upgrade existing facilities so that it provides the kind of services that are needed right now. On the downside of that is broadband is now going to be in the crosshairs of everybody else out there too. So you need to make sure that your policies and procedures and all this stuff we just talked about are in good shape, because there's never been a time like this where you're going to be more under the microscope going forward. So heed these warnings, please, and take care of yourselves and take care of each other. From 6 feet away, anyway.
And building on that, although there's not much enforcement right now, we expect that to change because of the increased scrutiny, particularly out of the FCC, who is being held to a higher standard given that net neutrality does not exist anymore, and that its broadband privacy rules were repealed. So this administration wants to make sure that it's keeping the broadband industry in order. At the same time, they've been very supportive, the FCC, of providing us with additional spectrum and some relaxed rules, but I do expect there to be increased enforcement once we get out of this crisis. I also expect there to be enforcement at the state level, particularly out of California, who has said that they are not relaxing their enforcement efforts on the CCPA, their new privacy law, even throughout this COVID-19. I expect other states to follow. So we want you to be successful. We want you to really serve your communities, but at the same time, we don't want you to spend all your money paying penalties and forfeitures and trying to fight class action lawsuits. So be safe, be smart, and let us know if we can help you in that effort. So thank you, everyone. We appreciate you very much, and we wish you the best of luck. Take care.